The FBI had Jeffrey Epstein in its sights as early as 1996. A formal criminal complaint was filed by a victim alleging child exploitation and the possible distribution of illegal images. Law enforcement had a clear opportunity to intervene long before Epstein went on to traffic hundreds, possibly more than 1,000 victims over the next 2 decades. And yet nothing meaningful was done for more than 20 years while Epstein constructed a global sex trafficking operation intertwined with wealth, power, and political influence. Critical evidence sat untouched inside federal files. This week, after years of public pressure, congressional demands, and survivor advocacy, the Department of Justice finally released what it calls the Epstein files. But what these documents reveal is not closure. They expose something far more disturbing, a prolonged collapse of federal accountability, systemic inaction by law enforcement, and signs that key information may still be deliberately withheld. Welcome back to Enforcement Files. This is the channel where we examine federal accountability, institutional corruption, and the moments where justice either confronts power or quietly steps aside. Today's investigation may be the most consequential episode we've produced on the Epstein case because the newly released records don't just detail Epstein's crimes, they reveal how those crimes were allowed to continue. After years of pressure from Congress, victims, and the public, the Department of Justice released tens of thousands of pages connected to Jeffrey Epstein and Ghislaine Maxwell's trafficking network. Expectations were high, transparency had been promised. Instead, the release raised immediate red flags, extensive redactions, missing records, and a structure that suggests damage control rather than full disclosure. Survivors and lawmakers alike are now questioning whether this release complies with the law or violates it. Let's begin with what happened on December 19th. That date marked the statutory deadline set by the Epstein Files Transparency Act, a bipartisan law passed with near unanimous support in Congress and signed into law last month. The mandate was straightforward. Within 30 days, the Department of Justice was required to publish all unclassified records related to Jeffrey Epstein, fully searchable, downloadable, and publicly accessible. The language of the law was explicit: no selective disclosure, no rolling delays, and redactions were permitted only to protect victims or minors, with written explanations required for every redaction made. When the deadline arrived, the DOJ announced partial compliance. The Deputy Attorney General stated that while thousands of documents were being released immediately, hundreds of thousands more would follow over the coming weeks. That statement alone triggered bipartisan backlash on Capitol Hill. The law did not authorize phased disclosure. It required full release within the 30-day window. One of the bill's co-authors publicly stated that the department had failed to provide any justification for its redactions despite the statute requiring written explanations. Another co-sponsor went further, accusing DOJ leadership of ignoring both the letter and the spirit of the law. This matters far beyond the Epstein case. When Congress passes legislation and the executive branch selectively complies, the issue becomes constitutional. The balance of power depends on enforcement of the law as written, not as interpreted by the agencies tasked with obeying it. If federal departments can delay, redact, or withhold records without accountability, congressional oversight becomes symbolic rather than functional. That is why legal scholars and civil rights attorneys are now openly using the phrase constitutional crisis. The DOJ maintains that its actions are necessary to protect victims. That concern is valid, but critics argue it does not explain the withholding of internal communications, charging memoranda, draft indictments, or decision-making records that contain no victim identifiers at all. What we are seeing is not a simple document dump. It is a controlled disclosure shaped by what the public is allowed to see and when, and that brings us to the next question. What exactly was released? In Part 2, we will examine the contents of the files themselves, what they reveal, what they imply, and why the redactions may be as revealing as the documents that survived them. So what did the Department of Justice make public, and what does it really tell us? The first category is photographs, thousands of them. Many depict Jeffrey Epstein and Ghislaine Maxwell at luxury properties around the world, private islands, waterfront mansions, penthouses, and yachts. These images span years and continents. They show a lifestyle built on extreme wealth, secrecy, and access. In many of the photos, Epstein and Maxwell are surrounded by young women, often dressed in swimwear or party attire, frequently in private settings rather than public events. While the images alone do not prove criminal acts, they reinforce survivor testimony about the environments in which abuse allegedly occurred. Several photographs also include well-known public figures. This is where the controversy escalates. Former President Bill Clinton appears repeatedly in the released images, not in crowded fundraising events or formal photo lines, but in relaxed private settings. In one image, Clinton is shown in a hot tub. His face is visible. The individual beside him is fully redacted. In another, Clinton appears in a swimming pool with Ghislaine Maxwell and another person whose face has been blacked out. In yet another, he is pictured aboard a private aircraft with a woman whose identity is concealed. Why does that matter? Because under the Epstein Files Transparency Act, the Department of Justice is only permitted to redact identities to protect victims or minors. No other category qualifies. That means every redacted face next to an unredacted public figure carries a legal implication. The DOJ itself is signaling that the person whose identity is hidden is either a victim or underage at the time the image was taken. That is not speculation. That is how the law is written. This detail triggered immediate reaction from both political figures and the media. Critics argue that if the DOJ is willing to release these images without explanation, it must also explain why specific individuals are being protected and what that protection implies. The Clinton's representatives responded by dismissing the images as old, irrelevant, and misleading. But the photos are not isolated artifacts. They form a visual record of proximity, access, and repeated interaction over time. And Clinton is not the only recognizable figure. Images also include Donald Trump, photographed with Epstein at social events in the 1990s, including gatherings associated with modeling and fashion circles. Trump has stated publicly that Epstein was around everyone in Palm Beach during that era and that photographs exist with countless people. That statement may be true, but it does not negate the importance of documenting who had access and when. Bill Gates appears in several photographs, including images linked to Epstein's aviation network. Gates has previously acknowledged meeting Epstein multiple times after Epstein's initial conviction, but denies any involvement in criminal activity. Other figures appearing in the photos include political strategists, entertainers, media personalities, and business leaders. Again, it is critical to state clearly, appearing in a photograph with Epstein does not automatically imply criminal conduct. Epstein deliberately cultivated relationships with powerful people. Visibility was part of his protection, but visibility also creates accountability questions. Which brings us to what is missing. Several categories of documents that Congress explicitly expected to see were absent from the release: draft indictments, prosecutorial decision memos, internal DOJ and FBI communications discussing whether to pursue charges and why those decisions were made. These records are essential to understanding how Epstein avoided serious consequences for so long. One of the most alarming omissions is a set of grand jury materials. More than 100 pages were released, completely blacked out, every word concealed, not partially redacted, entirely erased. No explanation accompanied the redactions, despite the law requiring written justification for each one. Lawmakers argue this is not compliance, it is defiance. The DOJ maintains that victim protection necessitated extreme caution, but legal experts counter that internal deliberations, timelines, and charging rationales can be released with names removed. The absence of those records suggests that the department may be shielding institutional decisions rather than individual victims, and that leads directly to the most damning revelation in the entire release, one document that cannot be explained away by redaction policy or bureaucratic delay. In Part 3, we will examine the 1996 FBI complaint that could have stopped Jeffrey Epstein before his trafficking network expanded, and why the Bureau's failure to act may constitute one of the gravest law enforcement breakdowns in modern history. Buried within the released documents is a single record that changes everything. In September 1996, nearly a decade before Jeffrey Epstein became the subject of public criminal scrutiny, a formal complaint was filed with the FBI's Miami field office. The complainant was Maria Farmer, one of Epstein's earliest known victims. Her allegation was direct and devastating. Epstein had taken photographs of her younger sisters, both minors at the time, and she believed those images were being trafficked. This was not a rumor. It was not secondhand information. It was a first-hand criminal complaint alleging child exploitation, and the FBI had it in writing. The implications of this document are staggering. In 1996, federal law enforcement possessed credible information suggesting that Epstein was involved in crimes against minors. This was years before his Palm Beach investigation, years before the non-prosecution agreement, years before hundreds of additional victims would later come forward. So what did the FBI do? According to the record, nothing. There is no evidence of a follow-up investigation, no documented interview of Epstein, no search warrants, no subpoenas, no referral to federal prosecutors. The complaint appears to have been logged and then ignored. After the release of the files, Maria Farmer spoke publicly, confirming that the document validated what she had been saying for decades. She described a mix of relief and grief. Relief that the truth was finally documented, grief for the countless victims who suffered afterward. Her words were simple and devastating. If the FBI had acted in 1996, much of what followed could have been prevented. This is not hindsight bias. This is not speculation. The complaint alleged conduct that, if investigated, would have triggered federal jurisdiction immediately. Child exploitation, interstate trafficking, and organized abuse were all within the FBI's mandate. The failure to act cannot be explained by lack of authority, which raises the unavoidable question, why was nothing done? Was it negligence? Was it incompetence? Or was it influence? Epstein was already wealthy by the mid-1990s. He had connections in finance, politics, and elite social circles. He cultivated proximity to powerful institutions. Was that enough to shield him from scrutiny? The released files do not answer that question, and that silence is precisely the problem. This was not an isolated failure. It set the stage for everything that followed. When Epstein was finally investigated again in the mid-2000s, the result was one of the most controversial prosecutorial outcomes in modern American history, a plea deal that effectively insulated him and his associates from federal prosecution. That deal has since been widely condemned by judges, legal scholars, and survivor advocates. But the 1996 complaint shows that the failure began much earlier and at the federal level. This is why survivor attorneys are now describing the FBI's conduct as more than a mistake. Some are using the term institutional negligence. Others are arguing it meets the threshold for criminal dereliction of duty, and the scale of the consequences becomes even clearer when we examine what the DOJ now admits about the scope of Epstein's victims. In Part 4, we will look at the confirmed number of victims, the organized nature of Epstein's operation, the political fallout surrounding the release, and what accountability, if any, may still come. One of the most sobering admissions in the DOJ's release appears not in a photograph or memo, but in a letter to Congress. During its review process, the Department of Justice acknowledged that it identified more than 1,200 victims and family members connected to Jeffrey Epstein's trafficking operation. Let that number sink in. More than 1,200 individuals, not allegations, not estimates, identified victims. This alone confirms what survivors have said for years. Epstein's crimes were not isolated or sporadic. They were systematic, organized, sustained over decades. One internal file referenced in the release, its title, Fully Visible, though its contents are redacted, suggests structured record-keeping consistent with a trafficking network, not an individual acting alone. The DOJ says it assembled a review team of roughly 200 attorneys to handle redactions and victim protection. That sounds substantial, but it raises an obvious question. If the government now knows who these victims are, what has been done for them, have all been notified, offered services, given access to compensation programs, have new criminal investigations been opened into anyone who facilitated or participated in the abuse? On these questions, the department has been largely silent. Survivors who have spoken publicly describe mixed emotions, validation paired with frustration. They see confirmation of what they endured, but not the accountability they were promised. Attorneys representing hundreds of victims have stated plainly that key records explaining how Epstein was repeatedly shielded are still missing. And that brings us to the political dimension. The release of the Epstein files has unfolded in a deeply polarized environment. Both major parties are now accusing the other of selective outrage. Some officials focus attention exclusively on political opponents who appear in the documents, while downplaying associations closer to home. The result is a narrative battlefield where Epstein's victims risk becoming collateral damage in partisan conflict. That politicization matters because it affects whether accountability will actually happen. Congressional leaders have already signaled possible next steps. These include contempt proceedings against DOJ officials for failure to comply with the Transparency Act, subpoenas compelling testimony from individuals with direct ties to Epstein, and expanded oversight hearings focused on why early warnings, like the 1996 FBI complaint, were ignored. There's also the legal front. Survivors and their attorneys are preparing civil actions against the federal government itself, arguing that law enforcement's failure to act despite credible evidence directly enabled further abuse. If those cases proceed, discovery alone could force the release of documents the DOJ has so far withheld. Meanwhile, journalists, researchers, and independent investigators are combing through what has been released, cross-referencing flight logs, contact books, timelines, and financial records. Even with heavy redactions, patterns are emerging, networks can be mapped, decisions can be reconstructed. The question now is not whether more information exists. It clearly does. The question is whether it will be released voluntarily or only after legal compulsion. The Epstein files were presented as a moment of transparency. Instead, they have become evidence of how deeply institutional failure can run, how long it can persist, and how difficult it is to unwind once powerful interests are involved. This release is not the end of the story. It is the beginning of a new phase, one defined by scrutiny, legal pressure, and demands for consequences that go beyond public statements. And that is why this investigation matters, because accountability delayed for decades is not accountability at all. The truth about Jeffrey Epstein's crimes, the people who enabled them, and the government agencies that failed to stop them is still incomplete. But every document released and every document withheld brings us closer to understanding how justice failed and whether it can still be reclaimed.